Crime in Court. My name is Heather, and this is another update in the Delphi case. This is of course Indiana versus Richard Allen, and we want justice for Abby and Libby, and Richard Allen too, if he is in fact a victim of this whole um, judicial system, if he's a victim of circumstance, whatever it might be. Maybe a victim of a cover up, we would like to know that. So, this episode, we're going to read through the state's response to the defendant's motion to dismiss all of the charges. So, the state has put forth a motion recently. We went through it, a second motion to dismiss the charges upon newly discovered, destroyed, and or missing exculpatory or potentially useful evidence. So this is all good reasons why the trial should be dismissed. They covered in their motion things that things like the interviews between Brad Holder and Brad Holder and company. I'll say and company, all of them, Elvis Fields, all of the names, Patrick Westfall. So let's just, when I say Brad Holder and company, all of those folks. So there were interviews that the police conducted very early on. They had been tipped off that Brad Holder and company were the ones that were involved, and those individuals were interviewed. However, that interview at the police station somehow got taped over. And they're claiming that it was just an accident and da da da, da, and it was days worth of video that had been taped over. And no one tried to make a record of any of the conversations that happened in those rooms after the fact either. So, and nobody tried to recreate it, to recreate that interview in the police office. So they should have, done something to rectify the fact that these interviews were they just disappeared. They should have memorialized that somewhere saying, hey, these interviews just disappeared and we accidentally recorded over them, but that wasn't found anywhere. So that makes it look very suspicious and very cover-up-y, if there's not something documented somewhere that this happened. Otherwise, it just looks like you're covering up something. So that's the argument with some of this evidence regarding the defense's side. So this is now what the state is going to claim. So let's read through this real quick, or as fast as we can. It's an 8-page document. And I believe it's Nick McLeland who authored it. I don't know who else is in his office. Yeah, it is. Nick McLeland authored it, or at least signed it off on it. So here we go. Now comes the state of Indiana by prosecuting attorney Nicholas C. McLeland and respectfully objects to the defendant's second motion to dismiss based upon newly discovered, destroyed, and or missing exculpatory or potentially useful evidence, and would ask the court to deny the same. Are we really surprised at all that he wants the court to deny this? To deny the dismissal of charges. I'm not, but I think there is a good faith basis that you should be dismissing the charges when you have all of this potentially exculpatory evidence that is missing or whatnot. All right, so there is no basis in the law or fact to support the defense's motion, and it should be denied. Further, there is no exculpatory evidence and or potentially useful evidence that the state has not turned over or is missing or that the state destroyed. Do we believe this? I do not. Um, the state has decided that it's just really going to bury the defense in discovery. So while they aren't turning over the things that the defense is asking for, that they need to defend their client, or things are missing, um, or taped over, or whatever they did. So that's a big problem. It's a big problem that all this, sorry, I got an itch. All this exculpatory evidence is potentially gone, and how are they supposed to defend their client when they don't have all of the data? So the rest of what they are receiving from the state is just a bunch of gobbledygook that they have to sort through and figure out what's what, and a lot of it isn't even helpful or useful, or some of it might not even be related to this case in any way. Or if it is, they haven't found a connection because it's just so much. They're just being bombarded by discovery now. So before it was, we're not going to give you the things that you're asking for. And now it's, we're just going to throw a bunch of discovery at you and say, oh, it's in there somewhere. Look for it. And they've given over all this information in a way that is not organized in any kind of rhyme or reason or fashion that makes sense to anybody. So even the state has said that it takes them too long to find things for the defense. So why should they be bothered to have to do that when you're the ones that organized it in the first place, and you should know where the things are, so you should be able to help them find. Yeah, this is the kind of garbage that prosecutors pull to delay, obviously, when they don't have a case. All right. Anyways, so further, there's no exculpatory evidence that the state has not turned over. Finally, Brad Holder is not a third party suspect, and there is no evidence tying Brad Holder to the victims in this case. In support of said objection, the state would ask the court to consider the following. So, um, I don't know where Nick McLeland gets off saying that finally Brad Holder is not a third party suspect when we know that he was a suspect early on. So, how can you say he's not a third party suspect when the defense literally is saying he's a third party suspect? He's a third party culprit, let's say. And that's going to be their defense, is that these other individuals who have said things or done things or whatever that make us believe that they were there or involved, those individuals should be held accountable instead of my client who's just sitting in a cell where he's being brainwashed and tortured by Odinist guards. This is ridiculous. Anyways, so in support of said motion, the state would like you to consider the following. One, that the law is clear. A dismissal of charges due to the state destroying or losing evidence is only permitted when the evidence is materially exculpatory or when the evidence is deemed potentially useful to the defense and the destruction of the evidence was done in bad faith. Well, that's what the defense is claiming. It was done in they're claiming it was done in bad faith, and they're claiming that this is exculpatory evidence. And how can you say that it isn't when you don't have a record of what was said or done in those interviews? Number two, the defense have not alleged any example of missing or lost evidence that is materially exculpatory or potentially useful to the case against Richard Allen, nor has the defense cited any example of the state acting in bad faith in destroying any kind of potentially useful evidence. Um, potato. You say no, they say yes. So that's why they need some kind of evidentiary hearing or some kind of third party to rule. Oh, an unbiased third party I'm talking about, not like a Judge Gull, but like a really unbiased third party to look at both sides of the evidence and decide, would it have been exculpatory? And was it destroyed in bad faith? Those are things that should be accounted for or looked into, And I don't think Gull's ever going to do that because she just wants this case gone, I think. Number three, that exculpatory evidence is defined as evidence that tends to establish a criminal defendant's innocence. State versus Durrett. Evidence is exculpatory if it clears or tends to clear the defendant from alleged fault or guilt. Brown versus State. For the destruction of materially exculpatory evidence to support a dismissal, the materially exculpatory evidence must be evidence that possess an exculpatory value that was apparent before the evidence was destroyed and must of such a nature that the defendant would be unable to obtain comparable evidence by other reasonably available means. Well, they can't. They can't find that other reasonably available means. That should have been the law enforcement documenting those interviews. They should have been memorializing it. And that's not up to the defense or the defendant to make them do that or to make them keep. Whoops, AI assistant. What? I don't know. Everything's AI now. Materially. Yeah. So how do we know that it? They're saying, how do we know that it was materially exculpatory? And my argument is, how do we know it wasn't? Especially when it's individuals that were being investigated um, in this case, in this crime. All right, number four, that the evidence to be potentially useful evidence, it must be evidentiary material of which no more can be said than that it could have been subjected to tests. Let me read that again. That for evidence to be potentially useful evidence, it must be evidentiary material of which no more can be said than that it could have been subjected to tests, the results of which might have exonerated the defendant. That's a very, very confusing sentence. And that was Wade versus State, apparently. To be subject to a dismissal, law enforcement must have destroyed that potentially useful evidence in bad faith. Bad faith is defined as failing to preserve evidence pursuant to a conscious doing of wrong because of a dishonest purpose or moral obliquity. Terry versus State. And this, I mean, you can't say that it wasn't done in bad faith, in my opinion, because it was several days worth. I mean, they probably did the several days worth because over that period of whatever many days, they interviewed multiple people that they thought were involved. And at some point in time, those interviews were erased, taped over, or so they say. So, how does police equipment just tape over itself? When you have interview rooms that are equipped to record, how did they just record over themselves? Like, is that even possible? I don't know. All right, number five. The defense identify three items of evidence that they allege were destroyed or missing, which support a dismissal, including Brad Holder's phone extraction, all evidence of Brad Holder's second interview with law enforcement, and a mimicked crime scene image found on Brad Holder's social media. They claim that these things are exculpatory or potentially useful and were destroyed by law enforcement in bad faith. And yes, that is what they're claiming. And there's some reason to believe that. It's not just some kind of pie in the sky conspiracy theory idea that's been floating around by the defense, which is what they would have us all believe, is that the defense are just throwing spaghetti at a wall to see what sticks. And that's not the case because things have been coming out in hearings that corroborate what Richard Allen's attorneys have been trying to, to say. All right, so number six, in regards to Brad Holder's phone extraction, there is no reliable evidence that the state ever extracted data from Brad Holder's phone. The only support that the state ever possessed Brad Holder's phone is in the May 2nd, 2024 Brad Holder deposition. The defense, in their motion, report that Holder indicated that he was pretty sure he turned his phone over to police. In addition to saying that he was pretty sure, Holder went on to say, "I'm not going to say that positively, but I'm pretty sure they took my phone. They took my son's and my phone." And that was from his deposition, page 13. I mean, you can't get any clearer than that. How can, I don't know why the pretty sure and I can't be positive, but they took my phone. I'm pretty sure they took my phone. They took my son's and my phone. So I think this is a um a way to like minimize it. Like, yeah, I think they did. But then he follows it up by they took my sons and my phone. I think that this is the true statement here. This is the yes, they did. They took my sons and my phone because he follows it up a second time. So I do believe that they probably did take his phone. The state believes that Holder is referring to February 17th, 2017, where he and his son were both interviewed at the Delphi Police Department. On at least two occasions in the deposition, Holder states that the police took both his phone and his son's phone while father and son were in the lobby of the police station on the day they were questioned by the police. When asked how he knew the police took Logan's phone, Holder said, "I'm pretty sure they did it right there in the lobby. I'm pretty sure they took both of our phones. Don't quote me on that because that was a long time ago." Well, you just got quoted on it. And so he says it twice in the same interview that I'm pretty sure they took both our phones. And he gives a location as to where they were taken. So that is pretty specific to me, which also makes me believe that they were taken. However, as documented in records previously provided in discovery, Indiana State Police Sergeant Brian Bunner collected Logan Holder's phone at Logansport High School on February 14th, 2017 at 12:45 p.m. Logan's mother signed the consent to search from to search form as the parent of Logan. So there's a form of um, consent that she signed. Brad Holder was not present. Sergeant Bunner traveled to Logansport High School and initiated contact with Logan and his mother prior to the victims' bodies being recovered in hopes that data on the phone may assist the police in locating the victims. So they took his phone. I mean, it just said prior to the victims' bodies being recovered. So they initiated contact with Logan, the son of Brad Holder, the day they went missing because it says prior to when the victims' bodies had been recovered, which was the very next day. So they went missing the 13th, they were found on the 14th, and so February 14th at 12:45 p.m., I guess they take Logan's phone. But that doesn't mean that they didn't take Brad Holder's phone in the lobby. I'm pretty sure they did it right there in the lobby. I'm pretty sure they took both of our phones. Don't quote me on that because that was a long time ago. He might not have remembered that they had already come to take his sons and they took his when Brad Holder came in to interview with the police potentially, later. So that right there is saying, I mean, can't get any clearer. It was before the bodies were recovered. Where was I? Yeah, Sergeant Bunner traveled to Logansport High School and initiated contact with Logan and his mother prior to the victims' bodies being recovered in hopes that data on the phone may assist the police in locating the victims. Brad Holder's account of the police taking his phone is unreliable since Logan Holder's phone was seized 3 days earlier and not, as Holder insisted, contemporaneous with the taking of Brad Holder's phone. Okay. They're saying Brad Holder's account is unreliable because Logan's phone was seized 3 days earlier. I don't think that that makes it unreliable. I think it means they might have taken Brad's phone in the lobby that day as he was being interviewed, but they had already seized Logan's phone. That makes perfect sense to me, and it doesn't necessarily negate what the defense is trying to say. So Brad Holder never says the police maintained possession of his phone or extracted data from it. The state is aware of no evidence that the police extracted data from Brad Holder's phone or ever had possession of it. Therefore, there is no evidence that the police destroyed or lost Brad Holder's phone extraction data, much less did so in bad faith. But isn't that interesting that Brad Holder says that they took his phone, but law enforcement has no record of it, and they also have no record of him ever coming and interviewing? All of these ties to Brad Holder are disappearing in law enforcement, even though that's where everybody should be looking, is this Brad Holder guy. So there's a lot of interesting reasons why you might think it's bad faith because there's some coincidences going on here. But of course, Judge Gull's not going to think it's bad faith on law enforcement's part. All right, so further, even if there had been an extraction of Brand Holder's phone that was destroyed or lost by law enforcement, there is no evidence to support the argument that data on Brad Holder's phone constituted potentially useful evidence for the defendant, much less material exculpatory evidence. Despite the defense's claims, there is no evidence, either physical evidence or witness statements, that connect Brad Holder to the crimes or the crime scene. There exists no nexus connecting Brad Holder to the crimes, and that is that goes to the opposite of the Franks memo and why they need an evidentiary hearing because he said, she said, tomato, tomato. I mean, the defense says one thing, and of course, Nick McLeland's going to say, no, it's not. It's the opposite because that just seems to be how these motions are going. They can't seem to agree on anything. The defense is relying on pure speculation that data on Brad Holder's phone was potentially useful to exculpate the defendant. They're not relying on that, but they're saying that, in conjunction with the fact that there's no record of it, there's no memorialization of it, there's no reports, no data, yet Brad Holder recalls his phone being taken, and there's also no record of his interview, which just mysteriously got taped over for some reason. And all of his friends, Brad Holder and company also had their interviews missing. So it's not just Brad Holder, so it does make you wonder. Number 7, in regards to a second interview of Brad Holder done by law enforcement. In his deposition, Brad Holder stated that sometime he believed maybe a year or two after his first interview, he was interviewed at the Logansport Police Department by two Indiana State police officers, a man and a woman. The state was unaware of such interview. What? He's interviewed by two state police officers, and the state is not aware of any interview of that nature. That's interesting. So, in the weeks following the deposition, the state has made efforts to determine if an interview of Brad Holder occurred at the Logansport Police Department. Recently, specifically May 28, 2024, so just last month, ISP Detective Roland Purdy reported to investigator Steve Mullen that he and Detective Lori Lemler interviewed Brad Holder in the fall of 2017 at the Logansport Police Department. Detective Purdy stated that he had learned that Holder had previously been interviewed and the investigation had ruled him out as a suspect, Detective Purdy says. But he was still a suspect to other law enforcement who are still pursuing that line of, still pursuing a theory that there might be some Odinist ties involved in the crime. there were some rogue officers, three rogue officers that, thankfully for Richard Allen, they were still onto the idea that this was some kind of odious tie, even though their superiors or unified command, the, you know, Liggets and Lesenbys of the world, they were all in this unified command, and Doug Carter and, all these people involved that are higher up in law enforcement, and the information would get filtered to them. All the information gets taken to the unified command, and then they do whatever they want with it. They filter it out. However, what these three officers noticed were that the unified command, anytime they went to them with anything Odinist related, they would just say, yeah, 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 forget that. But they didn't forget it. They didn't stop investigating it. They kept looking into it, thankfully. Um, that's Ferenci. I can't remember all their names. I'm like blanking right now. All right. So he said he and Detective Lemler met with Holder. Did I miss something? Detective Purdy stated that he learned Holder had previously been interviewed and the investigation had ruled him out as a suspect. He said that he and Detective Lemler met with Holder to learn more about what Holder knew about Odinism. Okay. Detective Purdy and Detective Lemler, Lori Lemler. So these were the two ISP investigators that met with him in the fall of 2017. They wanted to know what Holder knew about Odinism. Detective Purdy said that the interview was not recorded, nor was a formal report written. Why? Why wasn't it? That's a problem. There is no support for the argument that evidence related to Brad Holder's interview at the Logansport Police Department was destroyed or lost. But it makes you wonder why those officers went to talk to him about Odinism. Number one, that's dumb of McLeland to put that right there in paper. Like, there were officers that went to go talk to them about Odinism because they thought Odinists were involved. So there's another reason to believe that Brad Holder is involved, and that it is, mm, for all intents and purposes, it is Odinist related. There's some kind of Odinist tie. Where was I? All right. So neither is there any evidence that the Holder interview at the Logansport Police Department resulted in any potentially useful evidence, much less materially exculpatory evidence. Well, how can you say that? Because again, we're talking about Odinism. What did Brad Holder know about Odinism? Why did officers think that they needed to ask Brad about Odinists? And what did he know? What does he know? Can we be informed? Can we be told, us random citizens, to make sure that we feel safe as a community, that what was told in this interview could be memorialized somewhere? But it's not, because these officers went and talked to them about onanism for some reason, but didn't record it, didn't have any video of it or audio, nothing. Not even a formal report. So thank you for pointing that out, Nick McLeland. You just pointed out the fact that there's some more shady stuff going on by the investigators. All right. 8. Finally, the defense claimed that a key piece of evidence is missing, an image purportedly from Brad Holder's social media that mimics the crime scene. However, the defense not only acknowledged in their motion to dismiss that the image is in their possession, but that they showed it to multiple police officers in depositions, which the officers identified as coming from Brad Holder's social media. Therefore, the defense is arguing that the charges should be dismissed based upon the destruction or loss of evidence the defense currently possesses. There is no case law supporting such an argument. As stated in Chisel versus State, Materially exculpatory evidence is that evidence which possesses an exculpatory value that was apparent before the evidence was destroyed and must be of such a nature that the defendant would be unable to obtain comparable evidence by other reasonably available means. Like I said before, they can't recreate that interview, so there's no way to obtain it any other way. And how can they specifically prove that it was exculpatory without having the information? That doesn't make sense. But you can wonder, all these pieces put together, why? And it really makes law enforcement look shady. And it makes Nick McLeland look shady, like he's trying to hide something too. Number 9, that none of this evidence that the defense says is missing and or destroyed is exculpatory evidence for the case against Richard Allen. Well, that's tomato, tomato. You say it isn't. He says it is. We need to come together to have a hearing or something, some kind of an agreement, because it hasn't, the destroyed or missing evidence hasn't been presented yet to the defense. Brad Holder is not a third party suspect. Well, I beg to differ, and so does the defense. There is no evidence that ties him to the crimes of the crime of the victims in this case. The evidence ties Richard Allen to the victims in this case. Where? What evidence? So all of that, and then he just says the evidence ties Richard Allen to the victims in this case. But no, it doesn't. We all are wondering how you got to Richard Allen. Richard Allen doesn't make sense. Number 10, that the state did not destroy or lose evidence purposely in bad faith. The motion to dismiss is replete with unfounded allegations and distorted and misinterpreted facts. The defense make allegations that are not true and are not supported by any evidence whatsoever. The state's responses to those false allegations are as follows. A, that the fact that Brad Holder gave different answers to how many times he met Abby Williams does not somehow make items A through H, that's their evidence item, the way they have it tagged, A through H, exculpatory. So it doesn't make it exculpatory, but it does make Brad Holder a suspect. It makes him suspicious. B, that there is no evidence to support that the rune on Brad Holder's hand mimics the sticks found on Abby. Further, there is no evidence to support the facts outlined in the first Frank's memo. Again, they put forth 136 pages of evidence as to the Frank's memo. And there's plenty more that has come out since then. And there's been 4 Frank's motions now. So I think that they do have a case. Sorry, Nick, but you're wrong. C, that no portion of the October 26, 2022 interview of the defendant is missing. The defense has been provided with the entire recording. Okay. D, the Lieutenant Jerry Holman did, oh, he's another one, Unified Command. Lieutenant Jerry Holman did not lie in his August 10th, 2023 deposition when he answered the questions, was Brad Holder a suspect, with not really, no. Lieutenant Holman went on to state on the following page that Brad Holder wasn't really a suspect because the police had encountered him through Holder's son, who was a friend of the victims, and not just a friend, but a boyfriend, and was interviewed, and the investigation reveals he was at work at the time of the crimes. Okay. That the state has turned over to the defense the Todd Click letter and related reports and interviews after the state became aware that said items had not been previously provided. The state did not intentionally delay in providing the information to the defense, nor did the state intentionally conceal any evidence in this case. F, the state did not attempt to conceal the identity of the Purdue professor. Oh, yes, you did. Nor does his testimony contradict the testimony of Lieutenant Holman. Oh, yes, it does. This professor, Dr. Turco, has stated under oath that it is the defense who has mischaracterized his testimony rather than Lieutenant Holman. G. That the state did not intentionally delay providing the extraction data from Liberty German's phone, nor did the state conceal exculpatory evidence from said phone. H. The state did not conceal a report involving documented communication between Carroll County Prosecutor's Office investigator Steve Mullen and Indiana State Police Trooper Blocher, nor is the information in the communication in any way exculpatory or even potentially useful. Okay. That the defense's conclusion that 6.5 years after a complex criminal investigation began, officers had different recollections of what other officers believed during the investigation is somehow proof of a conspiracy to conceal officers' actual beliefs is a very strange thing. No, but when you have officers investigating a certain angle, let's say, then they are seeing something that maybe the other team isn't. They might be following their instincts a little bit more and following the leads that the other team isn't, or is trying to purposely steer you from. So those three individuals, Forensic, Click, and Murphy, those are the three. There we go. Forensic, Click, and Murphy. Um, the Todd Click letter. Those are um, the three individuals that were still following their instincts and looking into this when Unified Command and everybody else was saying, no, 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 don't look over here at this shiny object. Look over here. Look away from that. Come over here. Put your eyes over there. They're just trying to get you to distract you, potentially. I don't know, but it does seem that way when you have three officers that are still pursuing it, even after, I mean, you can get in trouble pursuing an angle that you don't or have permission to go after, but they believed in it enough to go for it. So I don't know, that says something to me. J, that Department of Natural Resources Officer Dan Doolin testified that he prepared a written report of his interview of the defendant, but could not relate any evidence that he had recorded his interview of the defendant and therefore believes he did not record it. However, he testified that he prepared his written report very soon after his interview and would have no reason to destroy the recording. K, that the image that the defense believe is a mimicked crime scene image is not missing. The defense is in possession of that image. And L, that Brad Holder is a key third party suspect is false. Again, there is no evidence tying Brad Holder to the crime. The defense cannot meet its burden to even allege that he is a third party suspect. Well, they can't because Judge Gull won't give them the Frank's hearing that they deserve, frankly. Wherefore, the state objects to the defendant's motion to dismiss for destruction of exculpatory evidence and would ask the court to deny the same. Respectfully, Nick McLeland. So that is the latest in the Delphi case. Where we're at, we just had the motion to recuse, the second motion to recuse Judge Gull, and her response, obviously, she said no. So that was the most recent activity going on there. And after her horrible response, I hope that the defense team has some kind of remedy that they can go to Superior Court and get Gull off of this case because she has no um what's the word I'm looking for? I'm having a brain freeze. She should not be on this case nor on the stand. anymore. Or not the stand, but behind the bench. That's what I mean to say. She shouldn't be behind the bench anymore. I think she needs to retire her gavel, retire her little black robe, and go home because she's not objective or unbiased at all. She is, she needs to go. And I'm sure she's going to deny this motion and rule in favor of the prosecution because that's how she's been going. But like I said, after they got the written, what do you call it? The written findings of Judge Gull, and she provided some of her, well, a lot of it is her opinion and snotty remarks, and part of it is just, I don't even know. Like, well, you want me to tell you the truth, so I can't not give you a source or whatever. I don't remember what she was trying to say, but she logically she makes no sense to me, and I think she needs to go. And I think Nick McLeland needs to go, and I do think they need to drop these charges because how did they get to Richard Allen? We went through on my channel. We went through the probable cause affidavit, and it doesn't make any sense that Richard Allen was arrested for these crimes. It makes more sense looking at this group of individuals who have said some really incriminating things to some people. We might, need some accountability for that. But because the law enforcement is whitewashing everything and saying, nope, nothing to see here regarding Brad Holder and company, then they didn't do it, obviously. So keep looking the other way. It's all an illusion. Crazy. Crazy that they think the public is so stupid. Same in Karen Reid. If you're not watching, if you're into Delphi and you haven't gotten into Karen Reid, it is so very similar in some ways because it's law enforcement, corruption, cover up, and it's really good. But very disheartening to know that these things are going on in our society today. But that's why we're here to learn and to grow and to do better. So thank you guys so much for watching. I appreciate you so much for being here. Please hit the like button on your way out. Thank you guys so much. Take care. Bye now.
If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.